Legal experts who do not contest actual court cases at trial stage offer simple solutions with to judge Supreme Court judgments which are obiter dicta judgments and which as per Article 141 of Constitution of India are not applicable to any other cases. Such judgments also cannot overrule three-bench judgments of Supreme Court which lays down rules and procedures. The check law is not child play that the accused can win by one argument or one cross questions or even one judgment. World-famous psychologist Murphy has said that if you have simple solution of any problem then it means that you have even not understood what problem is. Many experts lift one or two sentence or words from law or judgments and without realizing its correlation with other provisions offer simple solutions which does not work in actual trials. That is why more than 99% accused get convicted in check-bounce cases in trial courts. Section 20 of the Act says that once you admit signature on any check then you have given authority to the holder to fill the blanks. Another section 118 says that if you have admitted that it is your check then you are also liable to any liability related to this check. Section 139 also gives presumption of liability from the accused, however it has to be legal liability. But under the provisions of Evidence Act Section 17 and 58 once you have admitted it is your check then no evidence can be given to disprove liability against this check. All these provisions are overlooked and the accused is made to believe that by a flip of an eyelid the case can be won. And so there's miserable plight of accused in check-bounce cases in trial courts. In this situation we provide workable legal solutions in any check-bounce. Yes, the check law is presumptive law and in lack of legal knowledge the accused have given admissions at many stages. In this situation we provide a foolproof method to win any check case by the accused. We go one step backwards to the whole case. Accused should request the court to first decide whether the door of the room can be opened. Thereafter it will be decided what is inside the room. That is whether complaint is legal, its documents are legal and whether it is legally maintainable against the accused. Many the courts or the opponent may request the court that these issues are matter of trial and it should be decided by the court after trial. Here comes the importance of cross-examination of the complainant. We are dealing issues one by one in our videos. For examples, in many videos we have dealt with the issue of legal notice. When legal notice is legal, so the complaint is not maintainable. There are always limitations in written words, so most of the complaints have some or other legal mistakes. You have to carefully study such mistakes and have to create your offense counter-attack based on specific legal provisions and not just arguments. Offense, counter-attack is best defense. Now presently you are taking defense and in the process admit many facts which the complainant had omitted to state in the pleadings and so it becomes easier for the accused to get convicted. While in offense counter-action the complainant who never expected it so gets confused and makes more mistakes and so it becomes easier for the accused to win. In-depth knowledge of various legal provisions is essential to create a proper offense counter-action. You have to also understand the correlation between general procedural laws and special laws like check-bounce. Now coming to cross-examination by leading questions. Your advocate does not have experience of conducting cross by leading questions since in his or her daily routine no such opportunities arise. Many legal experts suggest cross by direct questions because it is their habit. The ego does not allow them to change. Why, where, how are all direct questions which proves the complaint and goes against the accused. And that is why the majority of check-accused gets convicted in trial court. To conduct cross at least 7 to 10 days practice is essential. The question should be asked in rapid fire and rising method like a staircase. The question should be framed in such manner that the only desired answer is received. Yes, yes or no, no, so that the responder gets hypnotized and will reply in desired way only. Any accused even without any legal knowledge can be trained to conduct such cross. The power of logic is immense. No fact can be proved by logic but any untruth can be proved. Basic foundation of modern science is standing on contradictions. The quantum theory which the Einstein proved says the matter is sometimes solid and sometimes wave. You, me and everything else is made of matter. But it cannot be proved. Coming to your roadmap of counter-action, the accused should always have more weapons of offense, counter-action in reserve and to be used if nothing else works. Application for further cross can be given at any stage in trial court and even at appeal stage by the accused. But it has to be well-reasoned application with relevant decisions of higher courts, which are many. One such most powerful offense counter-action strategy is the method of proving the evidence of the complaint. In all cases, the evidence of complaint is proved by leading questions, which is not legal, and hence there is no legal evidence for the complaint. Supreme Court in most important reference judgment of Verkey Joseph, in which the murder convict was acquitted because the prosecution evidence was given by leading questions. This judgment is being followed since last more than 30 years by all courts in India. What was in Verkey Joseph judgment? The evidence was given by prosecution by leading questions to its witness, so trial court convicted the accused for murder. Supreme Court said the prosecution evidence by leading questions is no legal evidence, and hence the accused was acquitted. When a murder convict can be acquitted by wrong method of taking evidence, the check bounce is a very small law, and so the accused can benefit. Please tell us from which place you are watching this video and what is the current status of your court case, if any. Please send email in English only. If you are facing any check bounce case, then our team will study all the documents and will suggest actionable steps in the case. There are many contradictions in complaint and also loose links in law, so it is easy to win any case. Accused can come out from open door, but due to pursuit for shortcuts wants to come out of the wall which looks near, and in the process gets convicted. This is the history of majority of cases in trial court for check bounce accused. The laws are made in English, so those who have cases in courts should develop expertise in English language. In this channel we give legal knowledge which can be actually used and not for publicity hype or for clickbait tricks. So please subscribe and also send to your friends who may have its utility. There is also more important development regarding appeals against acquittals. At present the appeals had to be filed before High Court. Now the Supreme Court in its order of April 2025 has mandated that the appeals against acquittals should be filed before district courts. So now the complainant will have one more opportunity to contest acquittal. First appeal in district court, then writ in High Court, and finally Supreme Court.